Hi, welcome back to Finally Revealed. In this episode, I want to talk about how you make a decision and the considerations to take into account on deciding whether or not to have a trial by jury or a trial to the court. There are four major areas. Two are kind of combined, and you'll see why in a minute. The first one is, are you able to have a trial by jury or to the court, which is just to a judge? Is it allowed? The second one is really two parts, the time and the money involved. Number three is one way or the other advantageous to you or your situation. And the final one is one or the other format necessary to the case? So let's start with whether or not it's allowed. Each court has multiple sets of rules. In various courts, you're not allowed to have a trial by jury. For example, a small claims court or bankruptcy court. Now, there are exceptions in bankruptcy cases where you can have a trial by jury, but in that bankruptcy court itself, you can't. If you have a contract dispute and in the contract it says the parties waive trial by jury, you're not going to be able to have a trial by jury. If you have a particular dispute, the type of dispute that is may dictate whether or not you are allowed to have a trial to the court or a trial by jury. And the final thing on whether or not you're allowed to have a trial to the court or a trial by jury is, again, going back to the rules of that particular court, how that request for either one is made. Is one of them the default setting? Is one of them automatic? Or do you need to make a request? Or if one of them is automatic, do you have to then agree to give up that way to go the other direction? And is it one side that decides, or do both sides or all sides, if there are multiple sides of the dispute, does everyone have to agree on one or the other? And there's timing involved in all of those. So what are the time frames involved, and when must those agreements or choices be made? So that is all wrapped up in whether or not it's even allowed. That's the first step. The next part, the next three parts get into why you would want to do one over the other. This is something you're going to have to talk with your attorney about. And things come into play such as location. Where is this physically going to occur? Is this close to where you live or work? Is this close to where witnesses live or work? Is it difficult to get there? Is it easy to arrange transportation or more difficult? When a trial is made to the court, it is just to the judge. And so there is not the practicalities of moving 6 or 8 or 10 or 12 people in and out of a room. That for people to get up and leave a room and get out of the room and come back in, it takes time. The longer that process of in and out of the room takes, the longer the trial is going to take. The longer the trial takes, the longer you're going to be off work and out of town if this is an out of town situation, or the longer this takes, the more you're going to pay your attorney because they're going to be dedicating more of their time to you. Witness fees are going to be increased because they're going to have to, if you have experts, they're going to have to be paid, and travel time and expense and all of that adds up. Just for you, I already mentioned the time that you'll have to be sitting there and taking away from your job or your business, or situations like that, or away from your family, child care, pet care, transportation costs, lodging if that's an issue, meals, all of that would have to be taken into consideration, and with all of that comes the money. Also, in the preparation for a court trial versus a jury trial, it's different. I have stated on several different videos, when we are presenting a case to a jury, that jury is a jury of your peers. So generally it's people in your socioeconomic range, maybe your age range, maybe live in your same location. Now, what you have learned going through the case and going through the experience of whatever led up to the case, you've learned a lot. A lot of that now has to be communicated to these people who may have no information, no background information to even know where to start. That's going to add on to the attorney's job to have longer questioning with witnesses, to maybe have other and more extensive evidentiary matters so that they can communicate effectively to the jury so everyone's on the same page. And so that adds to the time and the money. And then, of course, how you are paying your attorney is going to make a difference. If it's a jury trial case and you have a contingency case, however, you're paying the costs, which is travel expenses, witness expenses, and court reporters and things like that. If things run longer, the bills are going to be higher. The next factor to consider is whether one or the other types of trials is more advantageous to your position. Again, this will depend upon your communications with your attorney, what that person's experience is before the particular judge. Whether or not the case is tried to a judge or a jury, your case is assigned to a judge, at least through the pretrial part. In federal court, you have a magistrate and a judge. The magistrate takes care of pretrial matters, and then the judge is going to consider the trial and preside over the trial. In state court, I practice in different jurisdictions. In some, you stay with the same judge all the way through the trial. In others, you are assigned to a judge. However, they have general trial dates for jury trials. And so the only way you can be assured to have your judge that has been on the case since the beginning is if you have a judge-tried case, because in that court, the system is that yes, you will have a trial setting with a trial by jury in the division or court that with the judge that the case started with or has been with throughout the pretrial process. However, when it comes to the trial date, they set multiple cases on the same day. That's for the benefit of the jury. As I say on the jury videos, people that show up for jury duty, it's usually not for just one case. The court, for the convenience and try to do things in a reasonable and expeditious manner, will have multiple divisions having jury trials on the same day. So then they can all draw from the pool and reduce the likelihood that people are going to show up for jury duty only to be told we don't have any cases and then go back home. So in those situations, while you have a judge, you have your case set for a jury trial, if there are other cases in that judge's division that are ahead of yours, usually by date order, then if those other cases are going to actually go on that day and you're also scheduled for that day, they may move you to another courtroom. And while you're having your case tried by the jury only decides the facts. The judge decides the law. And there are many evidentiary rulings that are the decision of the judge, and you may now have a judge who has no familiarity with anything that has gone on in the case so far. So is that an advantage to you? It depends on the circumstances of the case and what has gone on. Do you want to take that chance? That's a decision that you need to make fairly early on if the court that you're in has that type of a system. So that's something to think about. Other words, advantageous could mean, is it a situation where you could get a bigger verdict? Are you going to get a better or bigger verdict as far as more money from a jury than you are from a judge? That depends on the judge, and that depends on the community where the case is being tried. Is it a community where people feel aggrieved and they want to hand over money like it's from a slot machine? Or is it a more conservative area where people are taking care of their own yard, taking care of their own business? They believe that everybody needs to be responsible, and maybe if something happened to you, maybe you brought it on yourself through some other behavior. And that is, again, something that you're going to have to talk about with your attorney. And what are the problematic facts in the case? Is a jury of 12 going to see things the way that you see things? Or is the judge going to be a better person to decide the case because it is something that is more technical in nature. Again, that is something that you need to talk about with your attorney. And then finally, is it really necessary to have one or the other to decide the case, a judge or a jury? What is the ultimate goal of the litigation? Is it a situation where it must be decided by the judge or it must be decided by a jury for this to be a beginning step that grows? Or does it relate to other cases? Is there some compelling reason that it should be or it's necessary to have it be a judge or a jury? Is this a civil rights situation? Is this something that is of national significance? Is this going to go on appeal, and is that the plan for this to be a test case of some kind? So is there some technicality or other underlying basis where it's necessary that it proceed in one way or another, other than going back to the very beginning, that it can only be one way or the other based upon how the case was set up? So I hope that helps you a little bit if you are considering this. If you are involved in litigation and you are not sure whether it should be one way or the other, that's something you're really going to have to look at all of these different factors and make that decision, if you can make a choice, if there is a choice to be made, which sometimes there is not. So if this was helpful or you learned something, give me a thumbs up. Leave any comments or questions below. Share this with someone who it might benefit. Subscribe to see the other videos, and all together now, come back and see me next time. Thanks for watching.